Okay, well, thanks everyone for joining us today. I think everyone participating knows me, Diana Parker with Ohio State Legal Services Association. And I want to start off just by thanking our co-presenters, Ohio Justice and Policy Center, the Columbus Urban League, and the Franklin County Municipal Court Self-Represented Resource Center, and Equality Ohio for participating yet again with us. We were really happy to co-sponsor an in-person January event where we worked together at the King Arts Complex and did this type of service. And so we're trying a new method, a new model. And so we appreciate your patience with us as we work through a new system that we hope will end up still being able to serve lots of people with their needs. I want to thank all of you for being willing to do that. I know that there's so much going on for everyone with your families or work, and so I appreciate your willingness to do something extra at a time when I know that can be a lot to ask. And when I say a lot, we hope to serve a lot of people. We certainly have a lot of people who are requesting the help. So the good news is that partnering with the Columbus Urban League has been a wonderful means by which we can get the word out to our client community and letting them know that we're providing expungement and record sealing assistance for folks. So that's been really great. I was frankly worried. I wasn't sure that we would have a good response because of COVID and because of everything going on and distraction and it being virtual, but we are continuing. Today's the last day of intake. We're over 200 people at this point, so lots of people who need help. So I'm just going to walk through the process just for a minute or two, and then I'm going to hand it off to Mike Zuckerman from Ohio Justice and Policy Center. He's going to go through eligibility, and then he's going to hand it off to Robbie Southers from the Self-Help Center, who's going to go through the forms with you just to kind of give you the basics. And this may be repetition for some of you, but we think that that's always a good thing. At least I know that works for me. So in terms of the process, essentially what's happened so far is the vast majority of clients are applying online on our website. A few of them are coming in through our phone intake system. It's at that point where we're determining eligibility. Out of the 200 plus people, I think we have, 9 clients who are over income for legal aid services. So it really is a population of folks who are looking for removing barriers so that they can get income at all or higher income. And just so you know, for those who are over income, we're still serving them through this event. Ohio Justice and Policy Center doesn't have the same income requirements that legal aid has. So they're able, and they have staff attorneys like Mike, who are able to actually take those cases. So anyone who's applying for services through this event who have Franklin County records, we're able to serve. We are getting some individuals who are from outside, from different counties and have no records in Franklin County. And so we're also at our stage, at legal aid stage, routing them to whether it's to OJPC or another legal aid provider who can help them out so that at least they're getting a referral. What we're also doing at the legal aid stage, which kudos to Kathy Shear, who I don't think she's on the call, and Patrick Higgins, who is, and Tracy Virgin. What we're doing right now is we are reviewing for eligibility, just doing a cursory review based on our conversation with the client or public records search, just to be able to separate out those who are just truly not eligible for record sealing so that we can then set those aside. We are sending information to them, advice about why they're not eligible, and then also offering them the opportunity to get CQE assistance, which we can provide to them. It won't be in this short period, but we will send them their CQE homework that we have, and they will get working on that. So we are sort of dealing with the out-of-county clients, dealing with the clients who are at least obviously ineligible. And then for all of the clients who appear to be eligible, we have started the process, which we started last week, where we are putting together criminal record summaries for each of those individuals. The most of those are being done by non-attorney volunteers or Tracy Virgin, who is our paralegal for our reentry team. And so we're getting those set up. Those are being uploaded to a report that then gets forwarded back to us. And then once we have that in hand, then we refer it to the pro bono attorney. So then we send you a copy of that criminal record summary, a copy of the client's intake, so you have their contact information, and then you are able to connect with the client directly, review their criminal record summary, make sure that everything is accurate, and then put together their their record sealing application. I should have noted that when they are talking to the non-attorney volunteers who are doing the criminal record summary, they're also going through, and I put this in the email, but just so you know, they're going through a verbal consent form. Since we're not having any in-person contact with them, we are going through explaining what we're doing for them. We're preparing their forms for municipal court. We were able to file their forms thanks to Robbie's program, which is a wonderful service. Robbie was able to obtain administrative order from the municipal courts waiving all of the fees for this event, so there's no filing fee for the applications. So for the municipal court cases especially, once the attorney uploads them, we're going to do a final quality control check through Robbie's program, and then Robbie will take care of filing those with the clerk, which is, again, a wonderful service that we're able to provide for folks. They will have the original copy that we email to them on hand, and then they will be responsible for responding to any court notices. So your assistance ends at the time that you complete your record sealing application for them. So for municipal court, that's the flow of it. There will be clients who have felonies in Franklin County, so the applications will need to be filed in Franklin County Common Pleas Court. We don't have that same, maybe by the next clinic we will have it all set up and we can do it virtually, but we don't have that same stream into Common Pleas Clerk's office. So for those, you will be preparing the forms and uploading them to your reports like you would for any of this. There's also a request for a fee waiver that you can help draft for them as well. And then we will send them to the clients and they will have to file those on their own, but they can apply for a fee waiver, which I think many of them will end up being eligible for based on the income of the clients we're seeing. But regardless, on your end, you just need to confirm with the client that everything is accurate and that they're eligible, prepare the forms, upload them to your online report, and then you are done. We want to build in, support and quality control because this is a high volume clinic and we know that we have a lot of new volunteers participating. So we are going to do a final check of the forms before they are filed through our staff and through Robbie's program. And then also next week, starting next week, we will have mentors available for about 5 hours per day. And I will be circulating that schedule by email today, and the mentor names and their email addresses, so that if next week, as you're working on referrals, questions arise that you can't answer on your own, that you would be able to connect with one of our lawyers who should be available to you in semi-real time. I mean, it just depends on how many questions they get as to how quickly they get back to you. I can't guarantee that if you're on the phone with the client, they can immediately email you back, but we should be able to get back in touch with you. And if Monday we are overwhelmed with questions, then we will add more staff to some of the shifts so that we can have a timely response to you. So that's, I think, the major points in terms of process. Like I said, this is the first time we've done an event like this, and we're hoping that this is a good system, but we will certainly be asking you for feedback after this to see what worked and what you think we can improve upon and what didn't work. And so if I think of anything else that I forgot to mention, I will just tack it on at the end. I don't want to take any more of the time. So I'm going to hand it over to Mike Zuckerman with Ohio Justice and Policy Center, and he's going to get us started on the real nuts and bolts of this. Mike?
Thanks so much, Diana. Good afternoon, everybody. I'm Mike Zuckerman. I'm an attorney with the Ohio Justice and Policy Center on our Second Chance team. So one of the things I work on is record sealing. I'm going to share my screen right now. And hopefully this works. All right. So I'm just going to take you through some of the basics of how to think about record sealing eligibility. And I want to make sure that I'll do a quick overview, and then I'm going to dive right into the nuts and bolts of how you determine whether someone's eligible and whether their convictions or records are eligible. I'll talk a little bit about alternatives to record sealing where clients are ineligible. And then I hope there will be a chance for just sort of general discussion at the end. I should say, I hope we can just have general discussion throughout too. Please feel free to send questions over the chat feature or just raise your hand or unmute and ask the question. I think it's good to pause whenever somebody has a question, we can talk it through. This is, record sealing is not And it's not, it can be complicated. It can be unfortunately complicated. And so you're doing a real service for people, especially who are going to be pro se in the system, and helping them understand what can really be, you know, a labyrinthian system and all these little legal intricacies sometimes. So just at the outset, a quick overview. This will probably be review for many people, but I just wanted to make sure everybody was aware of some of the terminology you're going to hear. So you're often going to see the words record sealing and expungement used interchangeably. They are technically different things under Ohio law. Record sealing is what we're doing through this clinic. It's what is generally the main game in town for people. There are limited situations in which expungement is available. Primarily, I think, you know, juvenile records. There are a few types of weapons charges situations, and then when someone has records that are related to their having been a victim of human trafficking, those are situations where expungement is possible, and that's where the record gets completely destroyed. Record sealing is not quite the destruction of the record; it's the hiding of the record from public view to most people for most reasons. So people are sometimes surprised when they get a record sealed and then they apply for a job in a highly regulated field like healthcare, and they get a government issued background check, like a BCI fingerprint check, and their sealed record comes up on it. That can happen. It sort of depends on the nature of the check, the nature of the job, but again, a sealed record isn't invisible to everybody. It's just invisible to most people for most reasons. So it's not going to show up on commercial background checks, for example. Most, you know, private employers in general aren't going to be seeing it. But one thing to be aware of, just last thing on this, is if you do see someone who you think may have the warning signs that they were a victim of human trafficking, that's something to probably raise with us, with one of the clinic supervisors, mentors, because they may be eligible for actually a even better form of relief, but it's a more delicate process. It's a longer process. People in general are not. We have a few dedicated attorneys at OJPC, or have had a few dedicated attorneys at OJPC who focus almost entirely on this work, and it can be really, really powerful for people. But again, people don't walk into clinics and say, I've been a victim of human trafficking. So you want to be on the lookout for signs that might suggest that that's been going on. And then feel free to just pause the conversation and reach out to one of us for some more, you know, for some consultation about that to see how to proceed. Many people use these terms interchangeably. But again, record sealing is what we are primarily doing here. So one other thing, just quickly, I always think it's important to pause about this. It's important to do this work for a number of reasons. And one of the really, really significant ones, obviously we have a wide-ranging criminal justice system in this country. It affects a huge number of people. There are some figures on this slide. It can affect all sorts of ways in which people try to build a flourishing life. Economics is one of the most significant ones, unfortunately. So having any kind of a criminal record, we know, sets people back financially and economically in huge ways. And you know, we're still, this isn't these aren't effects that are just distributed randomly across the state of Ohio, much like they're not distributed randomly across the United States. They have disproportionate effects on poor communities, on communities of color, and it can become a vicious cycle for people too. So again, we could spend a lot of time on why this is so important. I know that I have limited time, and I want to make sure that we get into the nuts and bolts of how to be most helpful to people, but it's just, I think it's important to pause on why it's so important to do this work. So with that, I will jump into determining eligibility. And I think of this as kind of a four-step series of questions, two of which are focused on the person's eligibility and two of which are focused on the conviction's eligibility, or the record's eligibility. So first of all, people have to be eligible to apply for record sealing. So if they're trying to seal convictions, their history of convictions has to satisfy one of two pathways. We'll talk about what those pathways are. Second, the person can't have any pending cases. We'll talk about what a pending case is. So those are two things that if those are going on for the person, that may be the end of the road for them for record sealing, at least today. Even if they are eligible for record sealing, that doesn't mean that each of their convictions is eligible. So the third question is this the type of conviction that is sealable under Ohio law? We'll talk about what those are and aren't. And then finally, again, if we're talking about convictions, there's a waiting period that has to have elapsed since what we call final discharge. We'll talk about how long that waiting period is. It varies, unfortunately, and we'll talk about what final discharge means. Again, I want to try to make this as simple as possible. Unfortunately, it can be kind of confusing, and there can be a lot of details here to follow. So please jump in with questions, because it can be. I know that when I started doing this work, I found it extremely, extremely confusing. So this is the schema that I found works for me. So again, I think of this as a kind of a checklist, and the reason that you need to know everything about a person's history is because having an extra felony out in Kentucky or Indiana might actually mean that they're ineligible for record sealing, even though you can't help them seal that either way, because it's not an Ohio offense. It still is going to affect whether they're eligible for record sealing. So that's why it's so important to know the whole picture of a person's case record of cases. So to dive into the first of these questions, there are these two pathways that I mentioned earlier. These are sometimes called pathway 1, pathway 2. I find it easier to remember them as the new pathway and the old pathway, because the new pathway is in general a little bit of an improvement. So I think of it as being kind of an opening up of options. But however it works to think about these things, there are these two basic pathways. And someone needs to be able to fit into one of them to be able to seal their Ohio records. So the new pathway, pathway 1, which tends to be broader but isn't always, has a few key things, and you have to check all of these boxes. So the first one is they can't have more than 5 felonies. They can have 5 felonies, they can have fewer than 5, they can't have more than 5. So if they have 6 felonies, they're out of the new pathway. And unfortunately, as you'll see, they're also out of the old pathway. They can't have any F1s, F2s, or F3s. So if someone has 4 felonies and most of them are F5s, but one's an F3, they're unfortunately also out of the new pathway. None of them, even one F3 is a poison pill to this pathway, unfortunately. Third, they can't have anything that's called an offense of violence. And I'll show you a table that lists what the offenses of violence are. They're defined by statute. They are not restricted to felonies or misdemeanors for purposes of being an offense of violence. So for being in this pathway, someone may have like an M4 menacing or an M1 assault, something that they don't think of as being a relatively serious offense in the universe of violent offenses. That will still unfortunately kick them out. It still is an offense of violence, even if it's what's thought of as a lower degree offense of violence. And then finally, they can't have any felony sex offenses. So these are things that you will need to be screening for to assess whether somebody falls into this pathway. Again, a few things to note. Felony traffic offenses do count. So if someone has a felony OVI, that's going to count toward the 5. So if they have 5 drug possession felonies and then 1 felony OVI, that's 6 felonies. There is no limit on misdemeanors, so they can have as many misdemeanors as possible, but again, you have to screen their misdemeanors, because if they have a misdemeanor offense of violence, they're still out of this pathway. And you don't have to memorize what all of the various offenses are. Again, we have some tables for you that you can refer back to anytime. And as you get more used to this work, you start to build a little bit of a running list in your brain, but I still go back to the list all the time just to double check. The old pathway, pathway 2, is a little bit different. You can have only 2 convictions. Generally speaking, you can have only 2 convictions, only one of which can be a felony. So 1 felony, 1 misdemeanor, 2 misdemeanors, 1 misdemeanor, nothing else, those would all work, but 2 felonies would not work. A felony and 2 misdemeanors would not work, except for some statutorily authorized grounds for legal creativity. So if there are 2 or more convictions that result from the same act or offense, the law says those can get counted as one conviction. If it's also within the judge's discretion to, I use the word clump for lack of a better one, but basically to count as one, 2 or 3 convictions that result from the same incident, the same court proceeding, or related acts within a 3-month span. So that is a kind of classic legal standard. It's the 3-month span thing is written into the law, but what exactly is the same incident? There may be room for some legal arguments around that. And again, it's discretionary by the judge. Minor misdemeanors and most traffic offenses don't count, but a more serious group of traffic offenses does count. So, I mean, things like OVIs would count. I'll show you what that list is. Again, you don't need to memorize it. There's a table for it. In general, the new pathway tends to be a little more forgiving than the old pathway, but that's not always true. There are going to be situations where someone will qualify under the old pathway, but not under the new pathway. So you want to evaluate people potentially through both. Again, if they have a large number of convictions, the old pathway is going to be obviously inapplicable, but if it's kind of on the line, there may be situations where the old pathway is going to help them more actually than the new pathway. So these are the tables. They're on a handout that I've linked to at the end of this presentation that we can send around. Again, there's a little code for understanding what those asterisks and number signs mean, but just for now, just know that these tables exist. You'll want to reference them. It is unfortunately a complicated feature of this. One thing I just want to point out as well, just in case this isn't complicated enough, there are some offenses that are offenses of violence if charged under certain subsections, but not under others. So one that you'll see here is burglary, what some people call a burglary charged under subsection A is an offense of violence. Burglary charged under subsection B is not. Looks like patient abuse or neglect is another one. Endangering children is another one that comes up. So just know about that issue. Know that if you see an offense and you want to look it up, seeing the words, just seeing the word isn't always enough. Like the word burglary doesn't mean that it's an offense of violence. You need to check what kind of burglary they were convicted of. And this is a table of more serious traffic offenses that are going to count toward pathway 2, for example, the old pathway. So this is the same slide I already showed, but I wanted to give an example of a situation where the old pathway might actually be more forgiving. So if you assume that your applicant has, the very scaled down hypothetical, but assume that your applicant has 1 F3 and 1 misdemeanor. So they're not going to be eligible under the new pathway. They're out because you see the F3. The F3 means no way they can qualify under the new pathway. The old pathway doesn't have that restriction. So if all they have is 1 F3 and 1 misdemeanor, they can still be, they can still be eligible through the old pathway. That doesn't mean that their offense is necessarily sealable. We'll talk about that in a second. Some F3s are going to be not sealable for other reasons. Some misdemeanors will be not sealable for some reasons, but again, they're going to be an eligible person for record sealing. So before we go further, I have a few little sort of more in-depth hypos scattered throughout this presentation. I thought now would be a good time to jump into one of them. So let's think about applicant A. Applicant A has no pending charges. We'll talk more about what that means, but for now you can ignore it. No, all cases have reached final discharge. We'll talk about what that means. You can ignore it. And the waiting period has elapsed. But this is their record. They have these 4 convictions. And the question is applicant A eligible for record sealing? Does anybody want to hazard a guess? I will tell you the answer to this one. Applicant A is unfortunately ineligible. And this is one that trips up people all the time. It's why I put this in here as a hypo. This is not a particularly, this person does not have what, someone might call a particularly serious history. They may be very surprised to hear that they can't seal their record. The problem for this person, they have only 2 felonies, so they're good there. The problem is this person has too many convictions for the old pathway. They have 4. And again, we're assuming that they're not all part of somehow the same case or same set of events, but they have 4 convictions. That's too many and 2 of them are felonies for the old pathway. They have this M4 menacing case. This is like this is the thing that frustrates people. I've seen this be very, very frustrating for client situations. Because menacing is a crime of violence under the statute, they are ineligible under the new pathway because they've been convicted of what's defined as a crime of violence. It's basically the lowest degree crime of violence, but it is nevertheless treated as one by the law. So unfortunately, this person is ineligible, even though they haven't been convicted of a violent felony or anything like that. Any questions about that? I want to transition now to talking about the second of 4 things that we think about when we think about whether a person's eligible. This is whether they have any pending cases. So this is not a great PowerPoint slide because it has a lot of text on it, but to be eligible to seal any record, you can't have a pending case. It's part of the statute. It says the judge has to check whether you have a pending case before granting your application. This is if you want to seal either a dismissal or a conviction. Non-convictions, convictions, they're all subject to the pending cases requirement. That's a difference from the rules I just talked about. People with 6 felonies can still seal dismissals, but they can't seal. But if they have a pending case, they really need to just wait and come back later. So the question is, what counts as a pending case? And this is a little bit unsettled across the state of Ohio. The rules in Franklin County are a little bit less friendly to people who want to seek record sealing, and the local practice is also a little bit less friendly to them. So this is going to be an obstacle for a lot of people in practice. And we can talk about some of the legal complexity about that. But one thing is clear, there's a published 10th District case called State v. JMS that says that if you're on probation, that means you have a pending case. So in this jurisdiction, in the 10th District, that is, that's currently a matter of there's law about that. There is a contrary ruling in the 1st District in a case called State v. Floyd. It actually went up to the Supreme Court of Ohio. It got mooted out before they could decide it. So we don't have a rule for the state on this question. But in the 10th District, probation means you have a pending case. You can't apply to seal anything if you're on probation. A separate issue comes up when someone has unpaid financial obligations. So they haven't paid restitution that was ordered. They haven't paid fines. They haven't paid costs. That could be in a criminal case, could be in a traffic case. Local courts, and I'll let Robbie Southers talk more about this, but local courts, my understanding is local courts have treated those things as pending cases the same way that they treat probation as a pending case. So that's an important thing to make sure the people you are advising are aware of. It's likely going to be an obstacle for them if they have unpaid costs, unpaid fines, unpaid restitution, and they're trying to seal anything. There is this other thing called the final discharge requirement. There is this there's a reason there's a split on this, which is there's also an argument that treating those things as pending cases is conflating the pending case requirement with the final discharge requirement. But again, in the 10th district, very clear that probation is a pending case, and the practice appears to be that unpaid financial obligations are treated the same way. So a few scaled down hypos here. One is that no cases are being prosecuted, everything's been wrapped up, they don't owe any money, total final discharge of the case. That person doesn't have a pending case, very clear cut. By contrast, also clear cut, a person is currently being prosecuted, they have a pending case, no doubt about that. They need to wait and come back when that's resolved. Someone who's on probation, clear here in the 10th district. The rule would be different if they have it in Cincinnati, would be unsettled in other places, to my knowledge at least. I don't know of another appellate case on it, but here in Franklin County, probation is also clear cut. They need to wait until probation has resolved. This fourth hypothetical, they owe money on a case, including a traffic case. Local practice, again, would say they need to wait until they've paid the money, resolved that, gotten the fees waived, whatever it is, and then come back after that's done. Again, I think that's a little bit of an unsettled question, but it's important to be aware of for purposes of counseling clients. Any questions about that? So the upshot of this is really, if the person owes any money, they're probably going to face an obstacle here in Franklin County, and they're not going to be treated by the trial court as ineligible or as eligible. They're going to maximize their chances of success, to move forward quickly. They would need to resolve the unpaid court debt. So in that sense, it can be a sort of an easy to remember rule, but again, it's important to realize there's actually a little bit of complexity underlying all of this. We'll talk later about what final discharge means and how it intersects, because they might also have to wait a period of time after they pay off the money they owe, if it's a fine or restitution.
So will the court records show that they still owe these costs?
Great question. They normally will. I will let Robbie talk more about some situations where it might be hard to figure out or how you can figure it out. But certainly on the Franklin County Municipal Court Clerk's website, I've found it usually very helpful in showing what the outstanding financial obligations are. The data in other jurisdictions isn't always as easy to work with. And again, there can be data issues anywhere, but the Franklin County Municipal Court Clerk's website tends to show if they have money owed and what that stems from.
And Connie, the hope is that we've caught those before we've sent them to you, but it is definitely good to double check.
Okay, good. And do you expect that we will mostly get muni court cases, or?
I'm not sure. I haven't looked at what's in the coffer yet. I'm not sure.
Okay. Thank you.
Can I ask a question as well?
Please.
So if we do find that they have unpaid fines, are we supposed to tell them that they should just wait? Like, is that the upshot?
So yeah, you would want to advise them of their ineligibility at the time and why. I mean, that's something that can be remedied, unlike some other of the categorical ineligibility issues. We're doing a lot of that now before we send them to all of you, but there may be times where we've missed something, and so that would be an opportunity for you to advise them about that and how long they're going to have to wait once they pay them off.
I would say if someone owes money and they're not able to pay it, have them come visit us at the help center. We can get them in front of court services and hopefully have the judge consider either a payment plan, a reduction. Some judges in normal times, less so with COVID, but will occasionally let someone do community service instead of paying a fine or a cost. There's some options we can explore with someone if that comes up.
Okay, great. And so should we advise them that they need to pay it off before they can file this? So should we finish the application and still submit it, or just, put everything on pause and say, come back to legal aid once you have paid this off?
That's a good question. I mean, I can't imagine that the application would substantially change even with the lapse of time, but it could, I don't know.
What we typically do when that comes up at the help center is we go ahead and just not do the application unless it's something small that they can pay off like within the next couple weeks. Because more often than not, they either lose the paperwork or file it by mistake. And it just causes more problems and more work than just redoing it once they've gotten that taken care of. Now it's different if they owe like $15 or $5 and they're gonna run down and pay that tomorrow, or they're gonna pay it online right then and there. But if it's a substantial amount of money, it probably isn't worth their time to do the application when they're probably just gonna wanna redo it anyway.
That makes sense. And Robbie's program and our program, we offer these services throughout the year as well. So it's not like they won't be able to get the assistance if they need help with them in the future. So that makes sense.
Plus they could get another case in the meantime.
True.
And Robbie, am I correct that if they owe costs, is the local practice that if they owe costs and they pay it off, they don't have to wait a year? Like if it's a misdemeanor, they owe costs.
Yeah, so only a fine will affect final discharge in that 1 year waiting period or the longer waiting periods for felonies. Costs don't affect that. One thing we've been trying to get changed that unfortunately hasn't happened yet is right now if someone comes down and say they owe some money on costs and some on fines, any money they paid is applied to the cost first and then to their fine, unless they get the judge to order to allow them to pay their fine first. So if they owe both, they're going to pretty much have to pay everything off before their 1 year starts. If they only owe costs, they can come down and pay those, and then literally after they leave the clerk's office from paying, they can come straight up to us and work on an application.
And it's going to become clear in a minute when I get to talking about final discharge why this distinction between fines and costs is so important. But there is this weirdness that if someone owed $5 in fines, they could go down and pay it off and still have to wait a year. Whereas if they owed $5 in costs, they could go down, pay it off, and then file immediately. So, which is actually a good segue. So this is this is my second part of this schema. So we've just talked about ways in thinking about whether the person is eligible to walk into court, walk into the courthouse and apply for record sealing. Now we're going to talk about whether the conviction they want to seal is eligible to be sealed at that time. So first, you assess whether the person's eligible. Second, you want to still check whether the conviction is eligible, because there will be people who will be eligible to seal some things, but not other things. So there's a list of offenses that cannot be sealed. I will sort of highlight this. I mean, feel free to refer back to this list at any time. Again, I would never expect anyone to just memorize these long lists, and I apologize for these slides with lengthy lists. It's unfortunately the way the law is structured. Mandatory prison terms is one thing. Not as common actually as some of the other stuff on this list. F1s and F2s will never be sealable. So if someone was convicted of an F2, that's just not sealable under any circumstances. Traffic offenses, except per rule, except for the section 2953.61, which I'll talk about in a second, but the general rule is traffic offenses can't be sealed. Felony offenses of violence, most M1 offenses of violence cannot be sealed. Again, this is where the weirdness between the person's eligibility and the conviction's eligibility starts to show up. And it's relevant generally in the old pathway, because you can have someone who has an M4 menacing or an M3 domestic violence who is not going to be eligible for the new pathway because it's an offense of violence, but may still be able, if it's their only offense ever, or one of two, may still be able to seal it because it is a sealable offense. Again, very confusing. It can get very confusing. So make sure to refer back to these lists, because getting the architecture in your head I think is helpful, but memorizing this stuff is hard. Most M1 offenses of violence are unsealable, but not all of them. So the largest exclusion, the most common exclusion is M1 assault. So someone whose only offense is M1 assault, or actually they have two offenses, M1 assault and F5 possession of drugs. They're going to be eligible under the old pathway, and they are going to be able to seal both of those offenses because M1 assault is a sealable offense. However, if you flipped it and they had F5 assault and M1 drug possession, they would still be an eligible offender under the old pathway, but they would not be able to seal their F5 assault conviction because it's a felony offense of violence. So again, this can get very thorny at the margins, but just know there are these carve-outs where an M1 offense of violence may still be sealable if it's one of these four things. And then it gets arguably even more complicated for sex offenses. Again, if you see someone with a sex offense, you just want to know to look that up and take it slow and figure out how it works, because some are still going to be sealable, like soliciting is going to be sealable, but others are not. So it's it can get complicated. And then the most kind of fact-intensive one, this can come up for people, is any felonies or M1s where the victim was under 16. So an M1 assault might be sealable in general, but if the victim of the assault was 15 years old, that is not sealable. So again, can get very thorny. Just things to be aware of, to be screening for, to be looking back at these lists for if you think they might be going on in a case. So another hypothetical that I threw in here, this is applicant B. Again, you can, we won't worry about final discharge or pending cases here. We'll assume the waiting period has elapsed. But this is applicant B's complete conviction history, and is applicant B eligible? And I'll give you a hint. This is like a little bit of a trick question. There's something going on here that I very briefly mentioned earlier.
Well, 291112. Let's see. A, burglary is listed as an offense of violence, and this is a B. So yep. This would be eligible then?
Applicant B is eligible. Exactly. Great. Yeah. Perfect. That's exactly what I was. What this question was getting at. This weirdness around A burglary versus B burglary. This person is eligible. They have 3 felonies, so fewer, 5 or fewer. No crimes of violence, because it's B burglary. If it was A burglary, they would have a crime of violence. No sex offenses. No no F1s, F2s, F3s. They're good under the new pathway. Yeah, perfect answer.
Okay, so I have another question. I'm looking at this little two sheet thing that Diana sent out, or 2-page, I'm sorry, sheet. Can I seal my criminal record? And step 2 is what can be sealed. That doesn't appear to be the same list as what you had on the prior slide. I don't see anything here about somebody under 16. It does say sex offenses marked with a pound sign if the victim was under 18, but I don't see any reference to somebody being under 16 on this.
Does
Anyway,
the form you're looking at say updated in like October 2018 at the bottom?
yeah.
Okay,
Yeah.
there's an updated in May 2020 version that's on our website. That is the better one.
Okay, so are you gonna give us a link to that or something?
Yes, it is at the end of this presentation. We can send it around too.
Okay.
Good eye.
And then one other question. So on that other slide, you said what can be sealed, and then it said anything can be sealed except, and then you listed some, but it seems like there was like a double negative, like except these, but except if it's this whatever, then it's okay. Am I reading that right? It looks like a double negative, like.
It is a double negative, and I'm sorry, I hope to continue refining this to make it clearer. The law kind of puts it forward as a double negative because they exclude these things and then they exclude things from the exclusion. So for example, they excluded M1 assault from, they said no violent M1s, and then they said but except for M1 assault, for example, or M1 riot. So you're reading it exactly correctly.
Okay.
Maybe the clear way to say that is just, yes, M1 assault is sealable, M1 riot, we can go back to the list.
Okay.
It's like M1 inducing panic. Yeah,
Okay.
M1 assault, those 4 are sealable.
But you will give us the updated cheat
Connie,
sheet.
the updated one I sent you this morning. It's in the email. It's the attachment to this morning's email.
Oh, I must have printed out the one that you sent me, I don't know, 2 weeks ago.
Yeah, I think that was from a couple weeks ago. I apologize, but the
No
new one is in this email.
Okay, thank you.
No, thank you. Good eye. Okay, the final of these 4 things that you need to screen for is this final discharge requirement. So has it been enough time? So
Mike,
again,
I'm sorry, can I ask one more question before you move on?
yeah, absolutely.
If they have like 2 offenses that are sealable and one that's not, can you still proceed to seal the 2 that are sealable, or does that unsealable one make it so their application is not valid?
Yes, they can. That is both the good and the bad. That's sort of the double-edged thing about this the way in which it's structured. You can have someone who is eligible to apply for record sealing, but they have one case that isn't eligible to be sealed, so they can't apply for that one, but they can apply for a different one.
Okay, perfect, thanks.
Good question. The fourth, we talked about these 2 ways that a person can just be ineligible. They themselves have too many convictions. They can't seal conviction. They can't seal any convictions, or they have a pending case. They can't seal anything. It's a blanket answer for them. Those were the first 2 things. The third thing was, are each of the convictions they're trying to seal, if they are eligible for sealing, are each of the convictions eligible? And we talked about places where the answer might be yes for some, no for others. Finally, there's this question of, has each case that is sealable gotten to a point where it can be sealed? So this is usually has the whole sentence wrapped up and has enough time passed. So the statute uses the phrase final discharge. The statute doesn't define that term, but it's been defined by the Ohio Supreme Court, which says that it does not occur until an offender satisfies all sentencing requirements. So some clear-cut ones are prison and jail, probation and parole, fines and restitution. This is, so actually, I think that you should disregard one of these bullet points, because I think Robbie just clarified that local practice does not treat costs as precluding final discharge. So actually, I don't know if there's a way to edit this while we're doing it, but ignore, can you see my, no, you can't see my, wait, oh, you can. Ignore this part of it. If they have outstanding costs, that should not affect their final discharge, but it does still, I think local practice still treats it as a pending case. So if they owe $5 in costs, they can't seal anything on any case. But if they go in and pay the $5, that case and any other eligible case becomes eligible immediately. On the other hand, if they owe a fine, if they owe $5 in fines and they go in and pay the $5 in fines, that case has only become finally discharged the day that they paid the $5 in fines, which means that the clock starts running from that date. So there is this generally unsettled legal question about what court costs should count as for purposes of final discharge. It sounds like you can advise your clients that if all they owe is costs, they're not going to have to wait a year after they pay the costs. They are going to have to wait a year after they pay something like a fine or restitution. They're going to have to wait a year after they get off probation. And again, I say a year is the amount of time for a misdemeanor. So the waiting period depends on the type of conviction. And if it's a felony, it depends on the person's conviction history. So for misdemeanor, it's pretty easy to remember. It's just a year. So once everything wraps up, the clock starts ticking. Once a year has run, that case can be sealed. Again, the 1 year clock starts from the end of paying the fine, paying restitution, ending probation, getting released from prison or jail, whatever it is. 1 year runs from that time. The latest of all of those things being resolved. The clock is different if they've been convicted of if they're trying to seal a felony. So if they have only one felony on their record, it's a 3-year ticking clock. If they have 2 felonies, it's 4 years from each of those two, from the final discharge for each of those 2 felonies. And then if they have 3 to 5 felonies, it's a 5-year clock from the final discharge of each of those 5 felonies. So again, because this requirement applies separately to each conviction, people are going to have convictions become eligible at different times. So you might end up helping someone apply to seal a disorderly conduct case, through this clinic, but they, got off probation a little while ago for a drug possession case, and they still have to wait. If it was a misdemeanor, they have to still wait a year for that case, or they just paid off the fine, they still have to wait a year for that case. But they could still seal the case that has been discharged for the requisite amount of time. So again, people can be eligible. This is another situation where the answer can be a patchwork. People can have some cases that are ready to go, other cases not yet ready to go. Questions about that? And again, apologies for the confusion about the costs and fines issue.
So this doesn't have anything to do with pending. I mean, for instance, if somebody is on probation or whatever, but they have other sealable offenses. So it's just that final discharge hasn't occurred, but that's not considered a pending case just because they're on probation. Is that right?
No, it collapses the two. This is why this is so complicated, and this is why there's a split among appellate districts. So in Franklin County, probation means they have a pending case. So in Franklin County, in Franklin County, they both have a pending case. If they're on probation, they both have a pending case and they haven't achieved final discharge. It's just that the not achieving final discharge is subsumed. It's sort of irrelevant because a pending case is even more of a barrier than not achieving final discharge, because a pending case sweeps away any eligibility, whereas final discharge just X's out that particular case.
Oh, okay.
I'd say a good hypo for that we see all the time is someone has 3 or 4 cases from maybe 2010 that they've all reached final discharge on. Those have been taken care of for a while. They then maybe relapsed or something, have a new case that they're on probation for now. That means they can't do anything while they're on probation. The day they get off of probation, though, they can come right into the office and get all of those old cases from the 2010 era taken care of right then and there because they've already reached final discharge on those. They're then just going to need to wait for final discharge on that current one. So that's kind of the situation we see most often, where final discharge and pending case could both come up.
Okay, thank you.
Any other questions about this? This is just a graphic. I tend to be a visual person. This is kind of how I think about the, this isn't at scale. So the time periods between indictment, conviction, and final discharge might be longer than a year, but this is just kind of how I think about it. But this is what you want to kind of run every potentially eligible conviction through this filter to make sure enough time has passed for that particular one. So again, in Robbie's hypo, the day that person comes off probation, all the old 2010 cases become eligible because it's been a long time, but the one that they just got off probation for is still subject to, is going to be within the relevant period of time, whatever, you know, if it's a misdemeanor, a year, if it's a felony, you know, and it's their only felony, 3 years, whatever the number is. So another hypo, yeah, just say this one's going to be more complicated because it kind of throws in all these issues. So take a minute with this one. So does anyone want to hazard a guess about applicant C let's assume applicant C lives in Columbus, and these cases all happened in Franklin County.
Well, it looks like the only bad one was the burglary, but it was dismissed. So if it's dismissed, does that count?
So, right, so that does not count. So the burglary, so that's one of the things that's one of the traps that's hiding in here. That's the kind of burglary that would be disqualifying if applicant C had been convicted, but you're absolutely right. Here, that was dismissed. So that's not going to affect their eligibility. Eligibility is only going to turn on crimes of conviction, not on dismissals. So if something was amended down or pleaded down, or they dismissed one count and the person was convicted of a different one, it's only going to be what they were convicted of.
And you can still, so this person, if they were eligible, would be able to apply to get that dismissal also sealed?
But if they're on probation, they're still pending, right?
Exactly. So that's the problem here. There are a couple things going on here. This person is not currently eligible here in the 10th district. Case one could be because the F3 burglary was dismissed, but right now they're not because they have a pending case. Case 3 is pending, they're on probation. So that wipes out everything, including the dismissal. Again, as Robbie's hypo really helpfully illustrates, the day that probation ends, the answer changes for cases 1 and 2. But assuming that this is just a slice of time today, are they currently eligible? the answer is no, not here in Franklin County, not in the 10th district, because they have a pending case. Answer would be different in the 1st district. But but in the future, they might be eligible to seal cases 1 and 2 the day they get off probation. They should be, but they're not current. If you're serving them through this clinic, they're not going to be eligible at this time.
What did you say about it would be different in the 1st district?
If this person were in the 1st district, probation wouldn't prevent them from sealing the other cases. Probation doesn't count as a pending case in the 1st district.
And are we supposed to know what district they're in, or no?
Well, we mostly won't be seeing cases from the 1st district is Hamilton County.
Mm-hmm.
If you see someone with cases from Southwest Ohio, it's worth reaching out to me. OJPC is headquartered down in Cincinnati, so we do a lot of cases down there. Most people are going to presumably have cases in or around the 10th district. Certainly, if their case is in the 10th district, JMS is the rule, which means probation is a pending case. If they're somewhere else, I'm not aware of a case that governs it. Again, there's just this split between the 1st district and the 10th district.
Okay.
If someone's unsure about what they want to do, I mean, you certainly feel free to contact one of us and we can talk about it more. But they should just be aware as well. I mean, even if a person is legally eligible to apply, for example, in the 1st district, the fact that they're on probation may still count against them. The court is still going to make a discretionary determination whether a person has been rehabilitated for purposes of sealing a conviction. And if they're still on probation, that can count against them anyway. So they should still be making an informed choice about whether they think that their chances are good at this time. But just, it's something to know that if, for example, you see someone with a Hamilton County case and they have this probation issue, the legal rule about their eligibility is different down there.
Okay. Thanks.
Thank you. And again, this was a question that there's a reason if it feels complicated, it's because it is. This is a question the Supreme Court of Ohio had taken up and was going to rule on, but unfortunately the case mooted out. So that's why we don't have a clear answer to how to deal with this. One more hypothetical. This is my last one. So any guesses about, and assume that this is today for purposes of the dates.
Well, I'm looking at the old list, but I don't see the offenses of violence. They don't appear to include these.
I'm seeing 2903-13 assault as an offense of violence on my list.
Okay.
One thing that's nice about the May 2020 updated version is that I think it sorts the tables a little more helpfully.
I see. Mm-hmm.
So this is one more kind of tricky one. It's getting at one of these wrinkles that we talked about earlier. Any guess about whether this person is eligible?
I'm going to go no based on my list, but maybe I'm missing it.
Well, so you're correct. The no is the answer for one of the pathways. Ultimately, the answer is
Oh,
yes.
the other pathway, they're eligible.
Right, exactly. This is
Okay, all
the
right,
thing
yeah.
that is so
Okay.
confusing about this. So you were looking at the new pathway, and you're absolutely right. They're not eligible under the new pathway because M1 assault is an offense of violence. Any assault is an offense of violence. However, the old pathway doesn't make the same set of distinctions. So the old pathway, sorry, go ahead.
No, the old pathway, you can have one misdemeanor and one felony, or two misdemeanors, and so say you have one felony here, so it is okay.
Exactly.
Okay.
And M1 assault is one of the excluded exclusions. It is M1 assault is sealable. If they had M1 domestic violence, that wouldn't be sealable. Because generally speaking, M1 and felony offenses of violence are not sealable. But M1 assault is one of the 4 exclusions from that list. So it's in other words, it is sealable. So this is again where and I'm not throwing these in just to be like tricky. These situations actually come up quite a bit. You see people with an M1 assault or an M1 domestic violence, and the answer can change. If the person had an M1 domestic violence, if we changed this hypo, the assault became a domestic violence, they would still be eligible to seal the drug felony, but the domestic violence wouldn't be sealable because it's not a sealable offense. So they'd still be an eligible offender under the old pathway because they only have 2 convictions, but one of those convictions would not be sealable.
Here's the question. On the convictions with a mandatory prison term, is there a way to know what those are?
Yeah, I mean, the truth is, in general, I can't answer this as gospel truth. I definitely don't recall ever seeing it in anything other than an F1, F2, or F3. That doesn't mean it's not possible in an F4. Or there is a bench card, I think, that with sentencing that sort of outlines all the mandatory cases. I mean, you can if you look up the actual sentencing documents, the judge should say either on the plea entry or the sentencing entry, it should say whether prison is mandatory. Again, it's going to
try.
Oh, go ahead.
We tried to do this research a couple of years ago. It's on like 15 different bench cards depending on what the offense is. Most of the time it's at least an F3 when it has a mandatory prison sentence. The one thing that I'd say watch out for is if a felony case has a gun spec, that's one time when like a case that otherwise wouldn't have one would. But there's not really a pattern or anything else to it. And there's no place that has like one complete list of all of them. So it's one of those you just kind of have to check if you think it's a possibility that it might have a mandatory prison sentence.
And
Yeah.
how do you check?
So I usually do 2 things. I mean, first I ask the client, because sometimes they'll just remember. They'll know, they'll say, oh yeah, I had mandatory time on that case. The other thing that you can do is go to the docket, and fortunately in Franklin County Common Pleas, they put the PD, as long as it's a relatively recent case, or even, last couple decades, they should have PDFs up for all the key docket entries. And so I go straight to the sentencing entry and the plea entry. And between those 2 documents, it should be listed whether prison was mandatory, because they're I think required to inform people of it. It certainly seems to show up on all of them.
Thanks.
Robbie, is that consistent with what you, and Patrick and everybody, is that consistent with what you guys do?
Yeah, that's what we do here.
So Yeah, so this is just one more, encouragement to go to the most recent version of this 2-page chart. There's a little tiny URL link for it, and just some screen grabs of it, but we'll also send out the link. And don't feel obligated to, obviously don't expect yourself to memorize what these tables are. I look back on them all the time, just to refresh myself or to make sure I'm remembering the rule for child endangerment correctly. And feel free as well to reach out to whoever is on the supervision or mentoring slot at any given time during the week. I think I'm probably either overtime or ad time, so I'm not going to go into. Diana, is that right? Should I just skip let me say one thing about it. Wait, sorry, you're muted, Diana.
Sorry about that. Yeah, if you could shift over to Robbie shortly, that would be helpful. I think we didn't really set a specific time since this was informal, but we'll have to wrap up.
I will wrap up as quickly as possible. Basically, I think the last thing that I wanted to spend significant time on was just the rule for non-convictions. So there's no waiting period for non-convictions. There's no waiting period for dismissals and acquittals. There's a 2-year waiting period for ignored cases or no bills. So if you see ignored or no bill, there is a 2-year window for that. But there's no waiting period for a dismissal or an acquittal. The pending charges rule does still apply here. So again, if somebody's on probation, they can't seal their dismissals either, but the day they get off probation, they can then apply to seal the dismissals. You're going to see cases, people will have cases with, 6 counts, and some of them are convictions, some of them are dismissals. The way I kind of think of it is like the rule is sort of, it rises and falls with the weakest link. So if one of the charges can't be sealed, in general, none of them can be sealed. So if the person was charged with 6 counts, but only convicted of 1, it's still going to, the question is, can they seal that 1? Not, can they seal the other 5? So the courts aren't going to like slice and dice the case up and seal the 5 dismissals and keep the 1 conviction. That's not how it works. It's basically, they rise and fall. If a case includes a conviction, it rises and falls with the conviction. There is this kind of complicated exception under section 2953.61, which is for if someone is charged with 2 or more offenses as a result of or in connection with the same act, and the final disposition of exactly one of them is a non-OVI traffic conviction. That is an exception. So a situation where someone was maybe pulled over for speeding and there was a small amount of marijuana discovered in the car, the answer might be different in that case. Because again, the general rule is traffic convictions can't be sealed. Traffic dismissals can be sealed, traffic convictions can't be sealed. But there is this, I think, slightly ambiguous, to my knowledge, kind of unsettled the extent of where 2953.61b goes. But if you do see a situation where there's a conviction that's linked to exactly one non-OVI traffic conviction, the answer might be different.
So, I'm sorry, so do dismissals or acquittals, like, do we count them when, like, if we're counting on the pathways, if they have 5 felonies and then they have a 6th felony that was dismissed, are they eligible or not?
Great question. They are eligible. Dismissals do not count. So someone could have been charged with F1 aggravated murder. If they were dismissed or acquitted, their answer is the same. That it is not. They are. If it was dismissed or acquitted, they can still be eligible. It's not going to affect their eligibility. We're only talking about convictions when we talk about eligibility problems.
Okay, and then if they had a dismissal of an F1 is that sealable because it was dismissed?
Yes. Again, the exclusions are applied to convictions. So yes, if someone was convicted, if someone was charged with, but was acquitted of whatever, that they are, even no matter what it was, whether it was an offense of violence or not an offense of violence, that they can apply to seal that.
Okay.
So yeah, those rules about being ineligible, unsealable offenses, those are convictions. Those are all for convictions. Again, a lot of the structure around this is built around convictions because that's what people tend to be more interested in sealing. It tends to be the thing that's creating the larger problems for them. But you do certainly get clients who they just don't want people to know they were charged with that offense, even though they were ultimately acquitted or it was dismissed. So I won't spend time on this. I want to hand it over to Robbie. Just something to know there. These are two tools that are out there for people who are not eligible for record sealing. Diana mentioned CQEs at the beginning, and people can be referred to Legal Aid Society of Columbus or OJPC if they're not eligible for LASC. For CQEs, which can help with employment barriers, and then pardons. There's a new expedited pardon project that does have some eligibility requirements. I have dropped the links in the footnotes, but I will turn it over to Robbie. Some more helpful links here. Most importantly, just want to thank everybody for being interested in this work and being part of our clinic.
Thanks so much, Mike. Really appreciate it. Robbie, you want to try sharing your screen?
Sure. Give me just a second here.
Robbie doesn't have a webcam, so you will only be seeing his PowerPoint during this.
Okay, can everyone see that okay?
Yep.
Great. So Michael did a great job talking about the eligibility and everything else. I'm going to focus more on what it's going to actually physically look like on each of the websites that we're going to be using, just because they're different. I mean, the municipal courts website and the system we're using is from the 90s, so it's not the best. It is a little confusing, but just wanted to give everyone a chance to see it before we go. By any means, as I'm going through this, if you have questions or want me to pull up the actual website and go through anything or anything like that, please feel free to stop me and let me know. So first website we're going to look at is the municipal courts website. The URL for it's pretty easy, just fcmcclerk.com, and then you'll see right over here, you'll click the search records button to get started. From there, it'll take you to this screen here, and we've put in the name of someone that we looked up some records, found some people that were ineligible. So don't worry, I'm not showing you records of something that's now been sealed, but this will just give you a good idea of what it'll look like. So the first way to start is start with the person's last name and first name. And in this case type, I always change over to criminal/traffic. That way you're not also getting all of their civil cases. If someone has a really common name like Joe Smith, you're also going to need to put in their date of birth. I will say, however, sometimes date of births aren't entered correctly or there's mistakes in them. So if you've got a name like this person we're using here, Maria Pasante, that you don't think there's more than one of them, enter it without the birthday to start with, just to make sure that you're getting everything, because there are occasionally some discrepancies depending on how the arresting officer put that information in when they filed the case. So after we search her name, we're going to get a result of this of all the different cases that come up under that name in this court. So we can see that this is all the same person because they all have the same birthday, and we can see the same middle initial or middle name through all of it. So that's just kind of an early check to do to make sure you're not looking at multiple different people, because obviously we don't want a case from maybe a Marissa F. Pasante to affect Marissa T. Pasante's eligibility. First thing you would notice on this record is before you even click on any of the cases, there's a red circle here telling you there's an alert. Oftentimes that means that person has an active warrant. and we want to inform them of doing that before we really do anything else. It could just be something as simple as they didn't show up for that traffic case, or it could be a more serious warrant. We encourage those people to call the public defender's office if it's more serious of a warrant. If it's something just that they missed their court hearing and they need to reschedule it, that's something to either refer to the help center or send down to the criminal clerk's office to get help with that. So once you've done that, seen if there's any alerts that show up, we're going to start by looking at all the criminal cases to check for eligibility. Criminal cases in this court are going to be the ones that have the CR in the middle of it. After that, we'll go back through and check all the traffic cases to make sure that there's no unpaid fines or costs in any of those traffic cases. So this is what it'll look like on at least part of the screen after you click on that first criminal case. So what we're looking at here, the case number, which will go on the application, is the first thing you'll see at the top of the screen. We can see that Ms. Pasante was originally charged with assault. We can see down here that that's not the final charge that she ended up being convicted of because she was guilty of the amended charge. And it'll show us the amended charge right here as disorderly conduct. The application also asks for date of result. There's oftentimes a lot of dates, and not all the dates are always the same like they are in this example. So the date of result is always the disposition date. So that's the one you're looking for as you're going through these paperwork, these versions of the form. Again, just a reminder of some of the common barriers that we see in this court. Not really much to go over with that, just a reminder that these are the ones that you'll often see come up as you're working on these. We had a question earlier when Mike was presenting about where the money will show up. In the municipal court, it's really easy. One of the sections as you're scrolling down the page is labeled financial summary, and you see a cutout of that here. That's where it shows any money that's owed at all. And it not only shows money owed, but it also shows any amounts that's paid. So you can see that Ms. Pasante still has a $25 fine that's outstanding. She still has $204 in costs that are outstanding. And then it gives the total amount that she owes down here at the bottom. We can see that at some point she paid $50 towards this. If you scroll down further, you can see exactly when that happened. Oftentimes when people see this, they'll say, oh, well, I made another payment that's not reflected or something like that. That's the time to call one of the mentors or something like that, and we'll see if we can figure out what that is. But this is where you'll always find the money when you're looking at municipal court cases, under that financial summary. I didn't take a screenshot of it, but oftentimes when you pull up someone's case, if they owe money, a big green square at the top of the screen will show up asking them to just make a payment on that money right then and there. That doesn't always show up, so don't depend on that, but that's often a quick sign without even having to scroll down that there's money owed in that case. Are there questions about that or anything else I said before I keep going?
Oh, is there any interest that is going to get charged to this?
No, our court doesn't charge interest. After a certain amount of time, these will get referred to collections. And at that point, collections does all kinds of different things depending on which collections agency it goes to. I will say most of the time when we send someone down to the clerk's office to pay, if they're willing to pay right then and there, the clerk will pull it out of collections and go ahead and just take the money. Sometimes if the case has been referred to collections, though, it means the judge is less willing to do something in terms of waiving some of these fines and costs or doing community service in lieu of paying them or something like that. But it's a little hard to tell that on the docket as much as just seeing what's owed. Okay. I know that's a long answer to a short question. Did I answer your question?
You did, thank you.
Okay. Any other questions about this before I keep going? Okay. Moving on to the next area, active probation, that being a pending case. There's actually a couple different issues on that screen, but let's talk about that first. The way you can tell if someone's still on probation here in the municipal court is down under the charges at the very bottom near the right. It'll give you the probation end date. I will say that's 90% of the time correct. It's not always correct. So if you see a probation end date, so for example, this one where that date actually hasn't happened yet, more than likely they're still on probation. Occasionally, if someone gets their probation terminated early, this date won't end or won't change, but it will change further down on the docket. That's the time to talk to that person and say, are you still on probation? Are you not? If they say, no, I'm not, make sure that they're not just on non-reporting probation, because oftentimes people will think that means they're not on probation at all. But they actually have to have gotten some kind of paper from the court saying their probation was terminated early, otherwise they're still on non-reporting probation. Another thing that we're seeing here, this person was originally charged with assault, which is an offense of violence. It pled down to attempts to commit an offense. With how our court is looking at the statute, an attempt of an offense of violence is still an offense of violence. So this attempted assault, for all intents and purposes, when you're looking at this person's eligibility, you need to treat it the same as if it were an assault. So yes, it's a lower level misdemeanor. Yes, they pled down, but the way our judges look at it, that attempted assault is still an offense of violence. I know that was a lot for one slide. Does that make sense?
Well, then why does somebody plead them down? I mean,
That's a great question. Under the old law, this may not necessarily affect it as much. So under that one felony and one misdemeanor track, an M1 assault would be sealable, but also this attempt would be sealable. A lot of these that we're seeing were just charges that happened a while ago. The other unfortunate thing that I would say is a lot of criminal defense attorneys just frankly don't fully understand all of the complexities of record sealing. So they may may advise someone to plead to this as a way to get that record sealed later, or at least get it to a lower degree without realizing that this is a thing that exists. That's why it's so important that criminal defense attorneys really understand this law, which is something we run into a lot. So it's very possible you'll talk to someone who says, oh, well, my defense attorney told me this would be sealable, but it isn't actually sealable.
I'm looking on the table 1, offenses of violence from that handout. And so when I look at the action code at the top, 2903.13a or 2903.13 is on there, but the amended action code 2923.02 for the attempt is not listed as an offense of violence. So I feel like I would have gotten this one wrong.
Yeah, and this is one that we were honestly getting wrong for a while until we saw, when the law changed, we did a few of these as kind of tests to see what would happen from some clients that were willing to do that. And every judge that's seen one of these in our court and over in common pleas has seen attempt as the same offense of violence as the thing above it. The strange thing about that offense of violence statute is it has a catch-all that says anything not listed that's also violent in nature. So prosecutors' offices here in Franklin County have used that to say an attempt of an offense of violence is an offense of violence. And because of that catch-all phrase in the definition of offense of violence, attempt should be considered.
So when we're checking, like when I'm checking the record and checking it against that table as reference, I should be looking at the action code at the top, not necessarily just the amended action
If it's an attempt, yes. If it's pretty much anything else, you would just be looking at what the amended one is.
Okay.
Really, attempt is the only time that this shows up is something strange. But that's why I'm showing it here, just to make you aware of it, because it is a really strange thing that our prosecutors and our judges have been doing. Okay, does all that make sense? Are you ready for me to move on then? Great. So we've already kind of talked about this, so I'm just going to kind of go over this quickly. Under the old track, domestic violence M1 is an offense of violence and not sealable. but an M4 domestic violence is eligible, but that's only if they have 1 misdemeanor and 1 felony or 2 misdemeanors. So just be aware of that when you're looking at domestic violence charges. If they have an M4 domestic violence, we really hope that they can be eligible under that old law. Again, traffic convictions.
And that's
Yes,
because
sorry.
the new law says you can't have any offenses of violence, right? But you
Right,
could
and the
get-
old law had a carve out of certain lower level offenses of violence
Okay.
wouldn't count towards eligibility and could still be sealed. But the new law, when they wrote it, they didn't include that same cutout in it.
Okay. Thanks.
Just a quick reminder, traffic convictions are ineligible for sealing. Dismissed traffic cases are eligible to be sealed, so you can put those on an application, but every single charge in that traffic conviction needs to be dismissed. So that's where you talk about, like, say they got caught for speeding and not having a valid driver's license. If both of those two things got dismissed, then that case could be sealed. And then Mike talked about this briefly. Anything that comes out of the same act or occurrence, even if it's in 2 separate case numbers, that whole act or occurrence needs to be sealable. A common one we see in our court is something like this of possession of drugs and a failure to signal, or an OBI or something like that. Usually what happens is that person got pulled over for failing to signal in this situation, and then they found marijuana in the car. If those two situations are factually connected, as in the reason they failed to signal was because they were using marijuana or something like that, the possession of drugs, even though it was dismissed, would not be sealable. This is a case that would require an attorney to make an argument that they just happened to find marijuana in the car at the same time they got pulled over for failing to signal, but they aren't necessarily factually connected. That's a tough argument for someone to make pro se. And so typically if we see two things connected like this, we encourage them to go and talk to legal aid or get an attorney that's able to go to court with them to make that argument.
Oh, in the last presentation, I thought there was one exception to this, but that sort of went by quickly when I was thinking about something else. Am I wrong? Was it just making the same point you're making now?
There is also, for these traffic convictions,
Right.
there is an exception where if there's exactly one conviction and then the rest are dismissed, that traffic conviction could be sealed.
So like
It's
in this,
very rare for that to come up, but it is a possibility.
but in this case, if this failure to signal were the only traffic conviction, then
Right.
you could potentially seal this as well as the marijuana one.
Potentially, if we're looking at it in that way, yes. If I remember right, when we took these screenshots, that failure to signal also had something else underneath it, like a red light or something like that.
Yeah.
More often than not, that's the case.
Okay.
But yes, if we're looking at that, that's the situation. I'd say a more common example than the one we've got here would be an open container, which is sealable because it's a CR conviction with an OVI. So someone got pulled over for an OVI and they also found an open beer can in the car. That open container is not sealable because it's factually connected to the OVI. So that's a more common one that you'll probably be more likely to see.
And the OVIs are never sealable?
OVIs are never sealable unless they were charged with OVI and every single thing in the case was dismissed. But I can think of one of those that I've ever seen ever. Next common barrier that we talked about are those open cases. A really easy way to see open cases here in the municipal court is just looking to see the status over here to the right and seeing that it's open. That means that person still has a hearing coming up, and that means they'd be ineligible to seal any of their other cases till that's done. Now, this last part for our court, this is the part that's really kind of confusing, and by all means, call the mentors for help on this. Arraignment cases start here in the municipal court, and then they can be taken over for indictment over in common pleas court. Because of how our systems work and the common pleas system doesn't talk to the municipal court system, a CRA case, which is an arraignment case, will show dismissed even if it was sent over for indictment and they ended up being convicted over in common pleas court. The way this works for record sealing is the conviction over in common pleas court has to be sealed, and then that common pleas judge sends an order over to the municipal court to seal any connected CRA cases. So the only time you'll put a CRA on an application is if it never went over to common pleas court. And honestly, I mean, we've got some tips here, but the reality is there's no good way to tell that other than just checking here and then going over to common pleas court and checking to see if there's a felony case that looks like it would be related. And this one, by all means, if you see a CRA and you're not sure, have one of us help you look it up, because we often have like 2 or 3 people checking on this anytime we do them here, because it takes a lot of eyes to make sure you're catching everything on these. So before I move into common pleas, are there any questions about the municipal court website that I can answer real quick?
So given this issue with the CRAs, and given that you folks are having non-attorney volunteers, prepare these record summaries, can we expect to see any of these? I mean, I would expect that we would either get one that was clearly a common pleas case or clearly one that was not going to be sent over to common pleas. Is that a fair assumption or not?
It depends. I mean, like I said at the beginning, we are screening these cases initially. So Kathy, Patrick, and other members of the legal aid staff would likely have already identified that. But it could potentially come up. It could be something where you see a CRA on the muni court, on the record summary that the non-attorney put together. That is a possibility.
Okay.
And we'll double check them all when they're all done. So if there's a CRA that got missed, or if there's a CRA that's on there that shouldn't be, we'll make sure that we fix that and have legal aid inform the client before we actually file it too. So at the end of the day, it's not a huge deal. I just wanted to make everyone aware of it, just so that they have all the information possible while trying to do these.
Sure, thank you.
Okay, moving on to common pleas. I will say common pleas website in some ways is easier to use, and a lot of other ways is a little more complicated. The first way it's more complicated is you can see the URL for it over here. I can never remember it. Honestly, anytime I want to go to this website, if you Google Franklin County CIO for case information online, it'll be the first result that comes up. That's almost always how I get to it if I'm on a computer that doesn't just have it bookmarked at the top of the screen. Because it is kind of a hard URL to remember. Much like on the municipal court website though, it really just requires first and last name. That's all we put in on this site. You don't need to worry about birthday, you don't need to worry about any of that. It doesn't really give you a place to put any of that in. So here we search Delando Radcliffe, and you can see all of his cases coming up here. We can tell that they're all the same person because the birthdays show up. Anything highlighted in yellow is the computer saying that's a perfect match for what you searched. Anything not highlighted in yellow is another option that they're pulling up. Don't trust the highlighted in yellow to be everything you need. More often than not, there's going to be more underneath that yellow highlighting. So I just tell people to ignore the yellow highlighting. So big thing is just to make sure these birthdays match. And then over here, you're going to see a couple different types of cases, CRs or any criminal cases. Delando also applied for a record sealing back in 2019. EP is their code to do expungement, which they use to count for all record sealing cases. So that would tell you that at some point, Delando's already filed to have his record sealed, and probably it's denied since we can still see records and since he's here asking for help. Looking into one of his cases, we can see the case number up here in the top left corner. You can see on this case that he was charged with a lot of different counts, and all of them got dismissed except for the money laundering, which is an F3. On some older cases, this isn't always 100% correct. So if you talk to a client and say, well, it looks like you were charged with an F3 money laundering, and they swear up and down that they were charged with like an F5 forgery, you can check the docket down below where it might tell you, or reach out to one of the mentors and we'll be able to help look that up. Just unfortunately, especially on older cases, their computer doesn't always update this the way it should. Again, you're going to need for this your case number, the charge, the disposition, and the disposition date, which I'll show you the disposition date on the next slide. But case number, charge, and disposition are all right here, right near the top. In common pleas court, the disposition date is a little harder to find. It's hidden down in the docket list for it, which everything you're seeing here is immediately underneath what you saw on the last slide. So you'll look through the docket and you're looking for something like plea of guilty to the indictment, or criminal disposition sheet filed, something like that that tells you that this was when the judge actually made the decision on the case. That's the date that you'll use when it asks for when it asks for date of result for this case. And again, these are sometimes hard to find. Don't be afraid to reach out to the mentors for help with this, especially on your first couple of them, because it trips up people quite a bit. Other issues, this is where we're talking about where the case didn't necessarily update, and I know this screenshot's small, but it says that he was charged with trafficking of drugs, which was an F3, but the disposition still says no plea. So this one is one that the computer just never updated to see what it is or not. So if you go down here to these images, which you'll see a little PDF symbol come up if there's an image, that's where you'll be able to see the actual judge's sentencing sheet where they checked off the boxes of what they were charged with, everything else. You can also see in this case, which we highlighted, that this person filed for expungement back in 2019. The prosecutor made some kind of objection to this record being sealed back then, and you can click on that image to actually see what that objection was back then. That's often helpful to look at to see, well, did they object because this person's ineligible, or is there some other policy reason why the prosecutor believes this record shouldn't be sealed? One thing I think we haven't really gone over yet is even if someone's statutorily eligible to seal their record, the judge still has to do a balancing test of the person's private interest in having this record sealed versus the public's interest in still having this record open. The prosecutor has a chance to make that objection and say that the public still has a strong interest in this person's record remaining open. And that's what was filed here, with some kind of objection. A common one that'll get objected to is if someone has been charged with domestic violence 5, 6, 7 times, and it's been dismissed every time because the victim has refused to appear and testify. That's a reason that the prosecutor would say, there's a policy reason this person, we believe still, even though that case was dismissed, has committed some kind of offenses of violence in his past, and the public has a right to know about that, even though the victim didn't want to come and testify. So that person will just need to show up to their hearing and explain in more detail why they have a really strong interest in having these sealed. And that would be talking about jobs, talking about getting housing. It would even be talking about why the public doesn't have a high interest in getting it sealed. So talking about how they've changed their life. A lot of people will talk about how they've been through rehab or how they've done something to move past whatever the situation is. So that's important to know if the objection that you're seeing is on a policy reason like that, that doesn't necessarily mean it won't be sealed when they apply again. They just need to give better reasons for why their record needs to be sealed. Does that make sense? Okay. Last thing to look at here, probation's a little harder to find in common pleas court. Again, you're going to go down to that sentencing disposition sheet and click on the PDF of it to look at the image. That's going to tell you how long their probation was, what the charge was that they were charged with, and then any other things that happened with the case. So maybe there it'll tell you that they also were given restitution in the case. They have to pay restitution to the victim. Restitution also affects final discharge, so if they still owe $100 in restitution, they're going to need to pay that before they can get to final discharge and get their waiting period started. So checking that sentencing disposition sheet will tell you a lot of information about these common pleas cases. And that's kind of the last piece that I have about what to look for, how to check the website, what to see through it. I know we have about 10 minutes left, so I'm happy to answer any questions. Again, especially with the Common Pleas website, don't be afraid to reach out to any of the mentors. I know I'm happy to answer any questions that you have because it takes a long time to try and figure out what this website says a lot of times. But by all means, we're always happy to answer questions, or I'm happy to answer any today that you might have.
So to visit the docket, is it like 3 slides back where it says either scheduling order or plea of guilty to the indictment? Is that the document you're going to look at?
So yeah, that plea of guilty to the indictment would be one. The better one to look at is 2 above it on 985, the criminal disposition sheet filed.
Yeah.
If there's an image for that, that's what's going to tell you what probation they got, what all of those other things that we need to know about.
Okay.
On this example, over here on the right, you can see that there's no images. A lot of the older cases in this court, they never scanned images in. So we have no way of knowing in this case when they got off of probation, when any of that happened, without asking the client.
How can you see that there are no images? I don't see what you're looking at.
So if you look over, and can you see my mouse on the screen?
No.
Okay.
Your mouse? No. Oh, now I do. Okay. Yep.
Okay. So over next to all these numbers, to the left of that, there would be a little image of a PDF. And let me switch to another slide that has one that you can see it. That's a pretty small screenshot. But if you see here where it says image, there's these little red and white pictures.
Yeah, barely, but I guess yes.
Yeah, it'll be a little bigger, but this website honestly is pretty small to look at.
Yeah.
Anytime one of those little red and white icons shows up, that's something you can click on and get a scan of some document that's in the file.
Okay.
I will say anything before probably about 2010, there's a good chance it wasn't scanned in. So that's when we're really talking to the client and trying to figure out what they remember and what they know about the case.
Oh, okay.
The lucky part for us is at this point, if they were sentenced to probation in 2010, there's a much better chance that they've now gotten off of probation and they're now at final discharge anyway. But it's definitely something to be aware of and to kind of talk to that person about.
Okay, thank you.
Robert, I noticed on the Muni Court website, it would say the level of the offense, like M1 or M4. Does it show that on
Yeah.
the common site as
Yeah,
well?
let me find a good screenshot of that. So this page kind of gives you a good screenshot. The degree over here to the far right, that'll tell you the level of offense. But like I was saying earlier, sometimes this top part isn't updated, especially on older cases. So that's when you want to go and look at that sentencing disposition sheet, look at the scan of it, and see what the judge actually physically checked on the checkbox. Because that sentencing disposition sheet will show what they were actually charged with.
But didn't you say that those aren't going to be available for older cases?
In older cases, they sometimes are, sometimes aren't. It just kind of depends. A lot of times it just depends on asking the client what they remember about this case, and basing it on the best we can figure out based on the information we have. Occasionally it'll be hidden somewhere else in the docket that a clerk entered a docket code that happens to show the conviction, that's something one of the mentors can help find if it comes to that. But hopefully we don't have any kind of weird issues that it comes to that happening.
Okay.
And a lot of the pre-checks, I'm assuming, will take care of a lot of these issues for you. So it's not something you'll have to worry about too much for the purposes of this clinic.
Robbie, I have a question for you in looking at, so everyone, when they get a client referral, is going to get a zip folder that has our forms for municipal court and common pleas. And we always have the probation worksheet in there for Muni. Should we be having the volunteers complete those?
Yes. So Muni requires a probation worksheet, which, Diana, is something I'll email to you, and if you wouldn't mind sending out to the volunteers, we have kind of pre-filled examples of what needs to go in each of those blanks that I can give you. Probation worksheets are required for any conviction that is an M4 or higher, and that's only for municipal court cases. So if someone has nothing but dismissals or maybe a couple minor misdemeanors and dismissals, they don't have to do the probation worksheet. Otherwise, anyone in municipal court will also be doing a probation worksheet.
Got it.
Really, all that worksheet is more personal information, and it gives them a chance to write out their story of how their life has changed, why they need this record to be sealed, the kinds of things the judge is going to ask at the hearing. It gives them a chance to write it out before they actually get to that hearing.
Okay, thank you. Any other questions for Robbie?
Well, I don't know who this question is for, but it seems like maybe the procedure would be when we get, when we get from you guys the client with the worksheet that the volunteer has put together, what they think are the offenses and all that, that maybe before we even try to contact the client, we just go online and look and see, if we think that's all, and then maybe call the client and fill out the stuff, or maybe even get a draft of it filled out before we call the client. I don't know.
Yeah, I think that's great. Every volunteer has their own preference on how they do it. I know that at our in-person clinics, some of our volunteers prefer to review the record summary before they bring the client back, because then they're just like staring at them as they review the court docket. So
Right.
I think it would make for a more efficient phone conversation, and you could kind of be ready if there are things that you wanted to confirm. And you certainly want to just go through it with them and say, like, this is what I understand your record to be. Is there anything else that you're aware of? And the consent that they affirm to on the phone, they're saying, they're agreeing to the fact that we are basing this on what they've told us. Like, we are not doing our own independent criminal background check.
Right.
So you do want to just, when you are talking to them, confirm that that's all that the client, believes that they have.
Okay.
Well, will they have seen the summary before we talk to them? Or do we have to walk through every single thing on the?
So we do not have that set up so that they would, but we can, Molly. That's a good idea. Every time we email them, then it increases the chances that they're just going to reply and ask us questions, which then kind of bogs down. But we can give that a shot with this number of clients. I can't guarantee I'll be able to field all of their reply questions, which inevitably will come up. But yeah, we can certainly give that a shot. Most of them.
I mean, that's okay. I think we could do that too. I guess just thinking if we get their email, then we could email them a copy of it right before our phone call and just have them tell them to review it before we talk.
Yeah, that I think would probably, in terms of the system, be more efficient and effective. And if they have an email address, that is provided on their intake. There are some clients who don't have email addresses, but the vast majority of them do.
But I thought, frankly, we were somewhat anonymous here, that we weren't necessarily giving them our phone numbers or email addresses, that, like when they walk into the clinic, you do the work the night of the clinic and send them on their way. Honestly, I'm not sure I necessarily want, people to have my personal email address.
Yeah, that's fine. I mean, like a lot of the volunteers have their work emails, and I think it's a little bit different, but I understand that, Connie. I get it.
Yeah.
And
Diana, would you object to me in particular using my BRC email address to do this?
not at all. I think that
Okay.
makes a lot of sense.
Okay.
Hi all, I'm sorry to interrupt. I actually have to run to a judges meeting, so I have to go.
Thank you, Robbie.
But feel free to email me with any questions or anything else.
Awesome. Thanks, Robbie.
Thank you.
Thank you. Bye.
Thanks.
Dan, I also have to run to another meeting, but thank you to everyone. This training was super helpful. I might have a few follow-up questions if that's okay from our group here.
Absolutely. Yep. And I'll forward the updated PowerPoint from Mike and some other things. So thanks so much, Molly. I appreciate all your help.
Thanks. Bye.
Bye.
Hey, Diana, a couple other procedural. How is this going to work next week in terms of the actual process of you guys, what we're doing?
Yeah, so Tracy will send the referral email to you, which I think I included in the instructions, kind of like an example of what that looks like. But I've sent so many emails, Kristen, I don't know.
That's fine. I can go back and look. Just give me a general idea what to
There will
expect.
the email will include a copy of what the criminal record summary, the one that was prepared. It will include a PICA, the PDF of the client's intake, so the PICA printout that Kristen's aware of.
Okay.
And then it will also include a zip file that has all the blank forms. And within the body of the email, there will be a link to the case reporting form. And that case reporting form is what you will ultimately, like, you click on the link and it opens up a form, and in the form you can upload what you've completed. So you'll like open the zip file, pull out the documents, whichever ones you're going to use, save them to your desktop or something, and then when you're ready to complete the report, you will upload them to the report. You just hit a button that says upload and find the documents on your computer. So then that will then automatically generate an email back to me and Tracy, so that we then know it's ready for the quality control check through Robbie.
Okay.
He'll get both of those reports. He'll get the report from the non-attorney volunteer with the record summary and your report. So if you found something different that was in the criminal record summary, you can put that in your report and say, found one additional item or something like that, and that all gets relayed to Robbie.
Okay. And when they're talking about the self-help or mentor, if we have questions, where are we going for those?
So the email that I send out, hopefully by
I need to go back and look at my email.
no, the future email. I haven't sent this. The email that I'm going to send out that has the updated PowerPoint from Mike. It's also going to include the schedule, the mentor schedule, for Monday through Friday of next week, that has the hours they're available and their email addresses, so that if you are deciding you're going to start working on it on Monday morning and questions come up Monday morning, then you'll email the Monday morning mentor. And so you'll see that schedule. Obviously, if like you email them and they don't get back to you until the end of their shift, they will still respond to you. They just might mean that they're backlogged with questions. And then, some experienced volunteers are taking like bulk. They'll take like 5 at a time and work on them. Others are just going to take 1 at a time. And then as you finish up one, if you're comfortable taking another one, then you just have to put that, to let us know, and we'll send another one to you.
Okay.
And honestly, I mean, our hope had been to only do next week in terms of the attorney services, but I think it is conceivable that we will have to continue doing this into the coming weeks. So for those volunteers who weren't available this week but might want to still help out, I think we'll still be referring these cases if we can't get through all of them next week.
Okay.
So Diana, are there other volunteers who are sort of private parties and not an institutional employee?
Yeah. We have a very diverse pool of volunteers for this project. Molly, sorry. My phone's been ringing off the hook, so I've been on mute most of the time. I sent an email out to about 150 of these clients, and so I'm getting lots of callbacks. Molly, who was on previously, she's with Kegler Brown, and they decided to do this as a project for a group of their attorneys. And so we have a few of the larger firm attorneys participating, but then many of our volunteers are on their own or retired, or we've had public defenders participate. A number of Mike's colleagues from OJPC are helping us. as well. So it's a pretty diverse pool. A lot of them have helped at previous clinics, but not all of them. So it's a
Okay.
mix.
Thanks.
Yeah. Anything else?
Well, I guess the one thing we'll have to see how it works is getting hold of the clients and having the clients call us back. I know I've worked at other clinics like immigration clinics, and sometimes the hardest part, especially if you're not, an office like you have where they can call in or whatever.
Yeah.
And if you're not giving them your private phone number,
Right.
that's one thing that might be a challenge. But
Yeah, it's possible. I mean, we've been doing this a lot with our virtual clinics since COVID started. So we've had like hundreds of clients served through the virtual advice clinics. And yes, there's certainly a small percentage of whom like we just have difficulty because they just don't accept block numbers. And then those we might have to like refer to somebody else, or, if we identify that as being an issue. That will probably come up with the non-attorney stage because they're the first ones having probably in the most cases the first one's actually having phone contact with the client. So we'll have a sense there if the client's just not responding. So that's definitely a possibility. I would recommend when calling from blocking your number to say, this is why I'm calling. I will plan to call you back at X time, so that they know that that's when that call could be coming through. That seems to have worked for some of our volunteers. And then when it ultimately comes down to it, if we can't reach the client for, you try multiple times, then, you can send it back to us. We'll send you a new client, and that it doesn't mean that we won't help that person. It just might mean that they won't be served next week through the special event. The administrative order that waives all the filing fees for this is general enough that it's not like time limited. It just refers to this as the event. So they're going to be able to file this through the self-help center process, even if it ends up flowing into a subsequent week. We would like to get this all wrapped up so we can go back to the rest of our jobs. I think I speak for some of us, but at the same time, like realistically, we have so many interested people that we may have to keep working on these later.
Yeah.
Patrick's going to Michigan for a camping trip, so he's just going to take a bunch of files with him and just get some Wi-Fi at McDonald's and finish those out. I'm just kidding. No one is canceling vacation over this, for sure. Well, I appreciate everyone participating today, and thank you so much for your questions and your attention. And as we said a bunch of times, we will be here to answer questions as they come up with individual clients. Thanks, Mike, and I know Robbie's already gone, so I will see everyone else later.
Thank you.
Thanks.
Bye.
Bye.
Bye.